Hearty welcome, hearty welcome. So it's a great day for us. All our gurus and well-wishers, guides are here. So it's a real great fortune to all of us. And we are looking for Dr. Ghulam Yazdani Sahab. He should also be joining any moment. So,
Fine. So we are very well within the time. I think if your all participants have joined, at least we two are here, me, Bharti, and you are having third speaker also. Uh,
Well, very good afternoon to you, sir, and to you, ma'am, also. Uh, it's a privilege to meet two stalwarts on this platform. So, Professor Bhatti and Professor Tandon, I really am so happy to be here today and see you on the platform after so many months and years, literally. So, yeah.
it's a really a great fortune to us because we wanted to have you all physically, but it was not possible because the exams were just over. So now students were also busy, but we thought let us have your gracious presence over here. So Simi Paul is our anchor. Simi, can we begin with it formally now?
Yes, sir.
Okay, so very good afternoon to the distinguished professors of law of the country and the very noble members of the teaching profession, those who are participants in the FDP program here, my colleagues, the distinguished teachers of the St. Thomas College of Law, Ms. Simi Paul is here, and Mr. Adnan is here, Dr. Niti Sinha is here, Mr. Fahim Khan, it is his brainchild. As a matter of fact, he conceived the idea of the FDP, and this has materialized. And I hope Mr. Adnan is here, and who else is with us? Mr. Dhananjay Mishra ji is here. So these are all our professors in the law college of the St. Thomas Law College, and our dean, Dr. M.K. Tyagi, should also be here around. So on behalf of the St. Thomas College of Law, our chairperson, Honorable Dr. P.C. Singh, and our vice chairperson, Professor S.C. Panda of the University of Delhi, and our director, Dr. Anuradha Amos, all our faculty members, our dean, Dr. Tyagi, and on my behalf, I extend a very warm welcome to Professor Usha Tandon and Professor Bharti ji, and in absence here, Dr. Ghulam Yazdani. And we were very lucky that we had our maiden program. It was addressed by Professor Manoj Kumar Sinha ji, another stalwart in the promotion of the legal education and legal research, and he was very kind and very enlightening address we shared with him. The St. Thomas College is basically a minority institution. It is set up by the Church of Northern India, and it is a sort of philanthropic kind of institution, because our aim is that the people, those who are underprivileged, those who are intellectually disabled, those who are physically challenged, those who are financially weaker, the St. Thomas institutions should help out these people, those who deserve all care by the society. And we owe the origin of this institution to one Miss Helen Jarwood. She was a foreigner. She came to India, and then she started setting up St. Thomas institutions. So we are very proud that St. Stephen's College is also in the hierarchy of that institution, and St. Stephen Hospital is also there, and very famous school, St. Thomas Girls School, Mandir Marg. It's a very popular school, and now over 100 years of age, and it has been credited also to produce Honorable Miss Justice Sima Kohli, Justice Rekha Sharma, Justice Geeta Mittal, and likewise the judicial people have been the people of the St. Thomas School. And so we are very very fortunate that we have joined that institution which is serving the humanity, particularly the weaker sections of the society, with regard to the promotion of legal education amongst the masses, those who deserve all care, all support by us. And our fees is also very moderate. We charge only for 1 year, we charge only 35,000 rupees, and those also in installments, and those who cannot afford, they are given free concession also. So very devotedly we have been working for the St. Thomas College of Law, and it is a great fortune of us that uh, you people, the professors of the country, Professor Usha Tandon Professor Bharti, and Professor Manoj Kumar Sinha ji, and Dr. Ghulam Yazdani ji, they acceded to my request. So it is a privilege with me also that I enjoy the patronage of you, the greatest of the scholars of the country in your respective fields. I extend a very hearty welcome to you, and I don't want to be in between your scholarly addresses and the participant, those who have joined. More than 50 people have joined from all over the country, all law teachers. What I feel sometimes very pity also that the classes are not very thick classes and very poorly attended classes by students, and we feel probably whether teachers are lacking or our system is lacking, why the students don't take interest and they don't attend to the classes. So that is a one area where our teachers have to devote themselves, that they should be so creative, they should be so fascinating that the students come. So with these words, I again extend a very warm welcome, and I hand over to Miss Simi Paul to kindly proceed with the program. Thank you very much.
Thank you, sir. Thank you so much. A very good afternoon to all. I'm Simi Pal, Assistant Professor of St. Thomas College of Law. It's my pleasure today to welcome you all on behalf of St. Thomas College of Law. Today is the second day of our faculty development program, and I'm sure this program shall prove to be an eye opening session for all the research scholars and teachers. So, we have with us, as Sir has already told us, that our guests today are resource person. First is Professor Dr. Usha Tandon. Ma'am is the Dean, Faculty of Law, University of Delhi. And we also have Professor Dr. Bharti. She is a professor of National Law University, New Delhi. So I would like to request Mohammad Fahim Khan sir to formally give a brief introduction to our guest, Professor Dr. Usha Tandon. So please unmute your mic.
Thank you, ma'am. Good afternoon, one and all present here. It gives me immense pleasure to introduce Professor Dr. Usha Tandon, Dean Faculty of Law, University of Delhi. It is an honor and a privilege for us, ma'am, to have you with us today. She is the world-renowned scholar for her work on human development focused on environmental protection and women empowerment. Professor Usha Tandon is well-known expert in the field of environmental law, population law, gender justice, and family law. Recently, she has submitted the country report on international research project on climate change, commitments, and an ethical analysis conducted by University of Auckland, New Zealand, and Windner University, USA, with support from IUCN, World Commission on Environmental Law, and its specialist ethical group. Her book on population law in India is the only book of its kind which covers various
Thank you,
population
Dr.
issues
Khan.
with
I
the...
think we can shorten on the introduction and should be in the
Okay, ma'am. Without further delay, I invite Professor Dr. Usha
permission
Tandon
of
to share her thoughts.
Professor Bhatti. Yeah, thank you very much. Thank you so much for the nice words in my introduction. Because it's half an hour which is given to me, and already we have consume some of the time. And it's so nice that whatever words you have spoken so far, Dr. Khan. Well, at the outset, I'm really thankful to the organizers, particularly Professor Bhatti and Professor Khan also, for making me a part of this faculty development program, which is on teaching pedagogy and research skills. Um I was introduced to this St. Thomas College of Law by none else than Professor Bhatti himself. And he's there in the advisory board of this college. And I'm sure that whatever progress in the few years established in 2015 and in just 6 and 7 years, the kind of the name which this college has earned. Um, Professor Bhatti's guidance is, we can say, bringing the fruits to these. So, as said by him, we are really looking forward those. Resuming of those days that we are again really physically interacting with the maybe the students or maybe the colleagues. But learning should not stop, and thanks to the technology that it has helped us to continue the learning herein. Uh, the kind of a system which we are having here, I could see 23 participants here. So, is there a separate link for the attendees? Or, they are included in this, whatever link we are having. Is this
Ma'am,
Ma'am, actually, if you are still joining, ma'am, so they will be joining.
okay? But it's the same link. It's the same
Yes,
link.
ma'am.
Okay.
yes.
No, these things are very essential to, how to proceed, but because that way. Fine. That's perfectly fine. So, the topic is before you, and that is, I'm going to take up environmental law and talk something about the pedagogy and the research skills on that. So, beginning, I'm just wondering how many of us who are gathered here um, are teaching environmental law or wish to teach environmental law or otherwise are having an interest in this study, so that accordingly, I can, uh, strategize my address or the speech here. Uh, Whether any one of you is, you can always, switch on your video and can talk. If any one of you is teaching environmental law or wishes to teach or is otherwise having an interest in it, fine. You are making my job, I will say, easy as well as
So,
challenging. So,
madam, so I once upon a time I taught environmental law in law college, but now I'm a retired person and still I'm working in another college as the principal. But at present I'm not teaching environmental law,
okay,
and I'm
okay,
very much
fine.
interested in it. I'm very much interested in it.
Okay, thank you very much. Fine. Uh, well, we are all, teachers here, whether of this college or the other. And perhaps we are also aware of this thing that this subject is a compulsory paper at the LLB level. Uh, I'm primarily addressing the teaching pedagogy at the LLB level. And Bar Council of India has prescribed a list of 20 papers apart from CLD papers, and this stands at number 18. That's one of the things. And another is that currently it is, if I talk about my own university, Faculty of Law, University of Delhi, it is not taught in the initial years. It is taught when we presume that teachers and as well as the students, particularly the students, are having some knowledge of other disciplines. And therefore, at law faculty, we are having it in 6 semester. I'm talking about 3-year law course. So, in 3-year law course, it is at the last semester. I have just browsed where in which semester this compulsory paper for environmental law falls in, and I found that as far as 5-year law schools are concerned, they are also containing it not before 3rd semester, right? Fine. So I'll be dividing by this short interaction with you into three parts. The first will be a kind of introduction in which I will try to introduce you about the nature of this particular subject, how this is different from other subjects. And number two, I will be coming again briefly on pedagogical skills, pedagogy to teach this paper. And my third component will be on research, how to do research herein and what are the techniques here, which primarily is the focus of this particular FDP, right? So starting with the first, you see, one of the things which we have to be very clear about this paper is that this is of recent origin. Like when I did my LLB in 80s, in 85, this paper was not in the curricula. I was not taught this paper, right? If I talk about my university, Delhi University Faculty of Law, it was introduced in 1991. Incidentally, I remember, sitting in the chamber of Professor P.S. Sangal. He offered me, I have just started teaching in 1990. In 1991, this offer came to me to teach environmental law. I knew nothing about that, and so therefore I refused that. But later on, I opted for it long back, thereafter. Fine. So this is of a recent origin. So if you want to know how old, we can discuss that also. But what I'm talking about, the environmental law, this is more in the sense of what we understand modern environmental law. Okay, so I will say it's hardly 30 years old or 35 years old, this branch of law. So it is still growing. It's not like our law of torts or law of crime, or for that matter, if I say family law, it's not like that. Okay. And one thing. Another thing is that the origin of this branch of law, what we say environmental law, is in the international. Therefore, those who wish to teach this paper should have some knowledge of international law. Not everything about international law, because international law itself is an ocean. And environmental law is one very prominent topic of international law. So those who specialize in in environmental law, the international level, call themselves also that they are expert in international law. Yes, they are right. Why? Because they know what is international environmental law, right? Again, herein I'm talking about what environmental law is known in the modern sense of the term. Why? Because if I'm talking about international law, then you will find some of the things there in the customary international law long back in Trails Matter case, etc. So when we are talking about modern environmental law, we are talking about more which is based on statutes, on recent treaties, etc., etc. Okay. So, at the international level, um, somewhere or the other, we relate its active origin, we can say, or the genesis from the Stockholm conference, which happened to be there in 1972. That's one. And then thereafter that the Earth Summit 1992. And then there happens to be Earth Summit. This was held at Rio. And thereafter it happens to be Rio plus 5, Rio plus 10, Rio plus 15, and Rio plus 20. So these two are the major one, which have really given an impetus for the domestic environmental laws. 74 Stockholm and 92 Rio conference. Uh, Again, when we are talking about environmental law in the international arena, then you somewhere or the other again be aware of what we call international law, soft law, and hard law. Uh, International environmental law is more of soft law and less of hard law. Not going into much details. Soft law, you know that the nature of international law, even though we now say it's gaining more recognition, this strength, that is, it's more in the form of the recommendations and directions. But wherever we are finding the treaties, then we say that's a hard law. It is legally binding. So we do have legally binding agreements also, but they are very, very few in number. Major portion of international environmental law is in MEA, multilateral environmental agreements. Number three is that the nature of this subject is that it is essentially a multidisciplinary subject. Now, this multidisciplinary subject further takes us to two things.
I request all to please mute your mic. Funny sir, your mic is not mute. Yeah,
Yeah,
please mute.
thank you. Yeah, so multidisciplinarity of the subject further takes us to two things. One is that the proper and the deeper understanding of environmental law also involves some knowledge of other disciplines. Other disciplines could be science. We talk about, we have to know in order to draft the environmental law at what level the voice becomes noise. So, how to find? So, it is only when the voice succeeds certain level we say it's a noise, and now we say noise pollution. Okay, so how to determine this? At what level uh, the dirty water will qualify to be polluted water? So all this comes from the knowledge of the science, not hardcore, but yeah, some knowledge of this. Then the other disciplines, say for example, sociology, philosophy, social work. Whenever there is any development project, displacement happens to be there. The whole villages are displaced, which raises the question. In law we say human rights issues, but this is also talked about in all these disciplines. You see, if 35 years before or so, the universities have or the law schools have introduced this discipline in their curricula, environmental studies have been introduced in other disciplines also. You will find a paper on environment, whatever disciplines I have mentioned you just now. You will find in social work, you will find in um, sociology and others, etc. It's a very, very important branch of knowledge in economics. Economics and environmental law are having very close relations. If time permits me, I will give you specific examples of all these. So, multidisciplinary means in order to understand the law, environmental law, we should have some knowledge. Some knowledge. It's not that you have to do diploma or degree in those, but yes, wherever the things are happening, we should be aware of how the scientists are thinking, how the economists are thinking, how a socialist is thinking, and even psychology also. I will say that is also a discipline in which these issues are talked about. Now, there is another aspect when I say the multidisciplinary disciplinary nature of this particular subject, and that is that even in the discipline of law, it is not stand-alone subject. The teaching of environmental law will also require you to refer other branches of law itself, like Constitution of India, like law of torts, law of crimes, administrative law, taxation, so on and so forth. But then it will be in a different perspective. When you will be discussing constitutional provisions, you will not discuss it, or the administrative law, or the torts law, you will not discuss it the way you teach those things in those subjects. Like nuisance, we talk in law of torts, but the way that the nuisance, the chapter on nuisance will be taught in the law of torts, and the way it will be taught in the environmental law class will be different, even though it is the same thing. That is, we are talking about the law of nuisance, right? Naturally, one of the things is that when we are talking about torts, it will talk about all kind of nuisances. But when we are talking about here environment, we are primarily talking about environmental nuisances. But then again, it is a matter of research. If you want to do a research in law of torts, how many are the cases which do not fall in environmental nuisance? Maybe you will find not a significant number of those cases. But again, I'm saying our perspective happens to be different. It has a very major environmental law, uh, has impacted another branch of law, administrative law, in a very uh, major manner. How come? When we teach an administrative law to our students, then we say the courts are concerned with the statutes, whatever is written in the statutes, they enforce the law. But administrative law, which is more in the form of rules and regulations on the policy, that is not enforceable by the court of law. But when you will start teaching environmental law and start teaching the case law to the students, you will come to know that what has gone to the courts of law, they were the cases, majority of the cases, what 100 cases, more than 100 cases of MC Mehta are there. You pick up any case, you will find what he's claiming before the court. He's claiming the enforcement of some policy of the government. So how come we teach in environment in administrative law the policies are not enforceable, but here in environmental law the cases are there which are basically the policy documents of the government. So it's a very, interesting way of looking at it. To give you a quick answer to this also, you will find that how beautifully in environmental law we connect policy um, with the fundamental rights. The moment we are able to connect policy with the fundamental rights, and there is a magical article, Article 21 in the Constitution, if it comes therein, then definitely it gets enforceable, right? Uh, okay, so that's the thing. Not only whatever is there in the syllabus, but all these other branches of these law itself. Some of those branches I have mentioned before you. Now, then, in environmental law, a whole environmental jurisprudence we discuss. It has come out. This is discussed in this the class of jurisprudence also, in the subject of jurisprudence also, and we call it environmental jurisprudence. And just now I mentioned that Article 21. So the whole environmental jurisprudence has come out from that one sentence, which says no person can be deprived of his life or personal liberty except according to procedures established by law. That small one sentence has given rise to so many jurisprudences. I'm just talking about here, environmental jurisprudence. And herein you will find that how this is a contribution of our judiciary, what we say, proactive judiciary, particularly the higher courts. I'm talking about Supreme Court, and yes, of course, the high courts also, right? But when you discuss cases to the students, again, you will find that we cannot deal with the cases in environmental clause in the same manner as we deal with the cases in our other classes. Why? I'll give you 2-3 reasons. There is one pattern or commonality with all the judgments which are coming, irrespective of which High Court it is coming or Supreme Court or which bench it is coming. And that is that one judgment can be relevant on more than one topic of your syllabus, right? So it's not that first of all you have taken any one of the chapters which was on precautionary principle, you talk about one of the cases, and then you will not talk about that case later on. You will talk about that case when you will be talking about, say, for example, the concept of sustainable development, or when you will be talking about, say, for example, Article 32, or, for example, if that was a case from the water pollution, when you are teaching to the students the provisions of the Water Act. So it's not that one case at one time on one particular chapter is complete. Now here comes the challenge for the teacher, and that is uh, how to really find out the ratio and the obiter of that particular case. Because this is a thing which I have noticed when students write in the examination, as well as so many blogs are there on the internet and so many articles are there on the internet, and how wrongly they cite the cases. And therefore, I'm emphasizing on the ratio of that particular case. What portion of the judgment you have to refer to the students, in what context, where the teacher has to be very clear about that. Let me just give you one of the example. There is one very important case, um, Indian Council for Enviro Legal versus Union of India. Generally, in environmental law, we do not talk about cases by its technical name. We talk the cases by its subject. Why? Because just now I told you there are more than 100 cases, MC Mehta cases. Okay, and MC Mehta was Union of India. So then you have to remember the citation. So instead of remembering the citation, we go by Ganga pollution case and Tanneries case, this and that. Similarly, this Indian Council for Legal Environment is having very many cases. Uh, if I introduce this case, which I'm going to present before you by the subject, it is popularly known as Bichri case, a fundamental case, in the environmental law. When you read this case, it's, hair-raising kind of the feeling you will have in this case. 1997, 96, 97 case, Justice Kuldeep Singh judgment. Now, this is a case wherein public interest litigation was filed in the court of law at a time when those noxious industries had already been closed under Section 133 CRPC. The petition was primarily for the restoration of the environment and for the compensation. Okay. Now, when you read the judgment, you will find that the judgment discusses all principles of environmental law. It discusses about precautionary principle, discusses about intergenerational, intragenerational principle, it discusses polluter pays principles, so on and so forth. I have read on the internet articles saying that Bichri case is illustrative on precautionary principle, which is absolutely wrong. Absolutely wrong. I mean, I will say it's a sin if we are giving the wrong information to our audience. Simply because precautionary principle was talked about in this judgment, maybe one para, two para, we as the teachers or the learners cannot say that when we are talking about precautionary principle, we can quote this case. Because this whole case was on what we can say, polluter-based principle at the most, right? But the style of writing the judgments of the judiciary happens to be that they do not take one principle which is applicable on the facts of the case. They take all the principles therein. Therein also there may be certain uh, what we can say compulsion of the judiciary in those years. I'm talking about 1996. Why? Because judiciary also takes its time to understand the evolving principles of environmental law. And just now I told you that the principles are at the stage of the evolution. Um, and when we talk about particularly the principles of environmental law, these whatever named I have taken, you must have heard all these: precautionary principle, polluter-based principle, sustainable development, etc. All these principles are overlapping. They are complementary and supplementary to each other. They are not exclusive. So that's the nature of this. But then as a teacher, you have to be you have to make your students very clear. Yes, they are complementary and supplementary to each other. But as far as this case is concerned, this is on this principle. The ratio of that case is on this principle. Right. So therefore, I'm saying that you have to be very careful, even though you are mentioning one case at 5 places in your classes. But which portion of the judgment have to be, in what context it has to be talked about, I think is one of the challenge for the learners as well as for the teachers. Okay. And another thing which you will find, again, I will say, pattern or the style how the environmental judgments have been written. You randomly take any judgment on the environmental law, and you will find it ends up in a particular manner, which is different than the judgments on other areas of law. And what is the difference with other areas and commonality between all these environmental law judgments is that it ends up in giving certain directions. It may be 3, it may be 10, it may be 20. And what are the directions? It may be from the High Court, Supreme Court, or even from the NGT now, which is exclusively there to settle the disputes relating to the environment. That state pollution control board has to do that. That branch of the government has to do that. And this is regarding the obligations of so many functionaries of the state therein. Okay. And another thing is that well, I'll be giving you some time at the end to ask us certain questions, but let it not be that boring one-way interaction between you. So if you want to stop me, interrupt me, you're most welcome at any time. I forgot to tell in the beginning, even though I thought of that I'll be telling you in the beginning, okay? So at any time, if there is anything, whatever I'm talking, you can interrupt. And though later on, we'll be having a time. So another thing, when we are talking about cases on environmental law, you will find one difference. When such kind of cases go in the court of law and any other kind of case go in the court of law. Court of law, which is adversarial system of law. I'm talking about those courts, our formal courts. Now, particularly those matters which go to the court under Article 21 as a PIL are not contested in the adversarial manner. There is one concept which we talk about herein. It is said the cases are dealt with in the court in a non-adversarial manner, in a collaborative, cooperative, and investigative manner. Because the pollution is degradation of the environment is so visible, it is before you. You cannot deny that. So at the most, the things happen to be okay. I mean, whosoever authority is responsible to maintain the quality of the environment, yes, okay, we'll take care of that, and then the things proceeded. And therefore, it is investigative also. I mean, there are very many interesting things how the burden of proof is also reversed, and that is also related to the investigative the litigation herein. So it's a very unique thing in the formal courts where otherwise adversarial setup is there. The cases are not fought like that. Okay, now. Taking you quickly, why? Because I have already exceeded my time, and Bharti must be cursing me that I'm eating on his slice.
Not at all. I'm enjoying this lecture so much. Yes.
Okay, so I'll try to wind up, and now I'm taking you to the second segment, which is pedagogy. Okay. Yes, we start with the lecture method. We can include other methods also. Socratic method also, I think, is included in the lecture method. We ask the students the questions, involve them in the discussion, which has to be there. And mind you, when you involve the students in the discussion, you will find a lot of information we may get from there. But if I talk about my own faculty of Law, Delhi University, we have students from all over India. From metropolitans, from far off places, this and that, and they tell us their stories. Once in my class, one resident of Bichri was narrating the story. He was saying, "Ma'am, just go there and see. Even though the judgment has come in 1997, even today the situation is not much changed. Why? Because still curative petition, revision petition, curative petition, this and that is going on. That's a different kind of a story. So they really give us the inputs on that. And I mean, in Socratic method, as all of us know, that we can have a this what is known as cold calling on the students and intrigue them, so on and so forth. Now, I will say, I have tried it in my classes, particularly in online classes. The nature of environmental law teaching is like this, that the teachers can bring visuals in the class also. uh, because you will find on the YouTube and otherwise also, which, say for example, if I want to narrate Bhopal gas tragedy, um, lot of material is there which I can use and to show my other students, or the Bichri case, or this span mortal case. So the geography, or if I'm saying that this was this highway project was carried on therein, and you see before this highway or this the airport, the it looked like this, and thereafter it is like this. So there are certain things when we give them certain visuals, the things really become very interesting and more clear. Why? Because visuals have an impact on our mind. But more important than showing them the visuals is for how long we have to show them. In a class of 50 minutes, or in a class of 60 minutes, I cannot show them 30 minutes or 20 minutes or even for 10 minutes. It should be very, very short ones, 2 minutes, 3 minutes, at the most 5 minutes. Because our purpose is not to show them a film or a documentary. Our purpose is to make you realize what we really want to, uh, and then initiate the discussion on that. Okay, so using is one thing, what to use and how to use, I will say, is more important than that. Another thing is that outreach learning we can also introduce as one of the pedagogical skills when we are teaching environmental law. But then it all depends which law school you belong to, how much privileged you are in terms of infrastructure, how much liberty you are having to have innovations, etc. So it all depends on that. We are more, I mean, we know our constraints. I to have been brought up, I will say, in this for so many years in this faculty. So what I do is, I cannot take my students for outreach activity at the institutional level. I can take, but for that I have to make so many arrangements, this permission, that permission. So what I do is, I tell them, say for example, if I'm talking about water pollution and there is a case on Yamuna pollution, I tell them, whenever you happen to go from that site, see this time Yamuna from a different perspective, right? Or wherever, whatever surrounding areas are yours, go and see them, but from this perspective, what we are talking about pollution, what we are talking about the violation of the laws, so on and so forth. I do encourage my LLB students, and they do I mean follow it also, because they come and tell me that whatever you have said, we have done that. I say, if you happen to go to Karkaduma court, don't miss out to go to the Center Pollution Control Board. That will also come in outreach. Just go and see it. You know, some, it's not necessarily that there has to be certain academic activity. I say, whenever you happen to be there in the central Delhi, just go see the National Green Tribunal, enter it. Say that you are a student herein. So even going and visiting these buildings to the extent you can enter in, I believe adds to the learning. Why? Because now you are a student of law. So when you are entering these places, when you are seeing the Yamuna, you are having certain perspective in your mind from which you are seeing that. So that's one of the things. So it all depends upon, again, as I have said, what liberties with you to introduce all these things. But you can definitely introduce this what I say, outreach learning there in the classes. And the last one I will include in the pedagogy is project work. It's really, I mean, this subject is best suited for project work, I'll say. uh, Maybe in the 5-year law course, certain projects are compulsory, or certain grades, etc., are given. Very, get very good work. And you see, if I just talk you, not at the LLB level, at the LLM level, when the presentations have to be given by the students, that's a kind of, I will say, project work for them also, how beautifully they present it. And I learn a lot from their presentations, the things which I was not previously aware of. So it's a very fertile area for this work. Now, quickly jumping on to the research skills, research areas, I mean, research skills, etc. Quickly, okay, two, three things I will be telling you. Number one, environmental law is again a fertile area for empirical research. You see, empirical research is not only that research which you do by going to the field, questionnaire, interview. That is definitely empirical study, but it is not only that. Empirical research also includes analysis of original data, analysis of data which is their what we can say primary data, right? And herein, uh, what will be your primary data? For primary data, you don't have to go anywhere. You just pick up the judgments of the NGT. You just pick up the judgments of the Supreme Court, maybe of 5 years, maybe of 10 years, or maybe only of 1 year, of the last 1 year, depending upon, I mean, what kind of a project you're working on. And herein you will find that I mean, whatever my a little bit research is there in environmental law, that is, if I can just share with you. Once I have written one article on how the NGT has come up on the implementation of polluter-based principles. So in the initial stage, there happens to be certain bright students. I ask them to collect these all judgments, and they are very quick also, better equipped than us how to find the judgment. So around 300 judgments, I have given the specific time period also, and around 300 judgments were given to me on the soft copy. And then, of course, a scrutiny comes in, and ultimately, what more? I mean, you will see why, because research is always focused, right? So from those 300 judgments, ultimately you will pick up just 10 or 15 judgments. That is an empirical study, because then you are reading those 10-15 judgments out of those 300 judgments, and then trying to make out some point, because all judgments may not be relevant. All judgments may be the repetition of just one of the principles. So what is something new, uh, maybe progressive, maybe regressive? So on the basis of that, we, I mean, zero down the judgment, this and that. So you can take anything, any one of the things in environmental law, and even the case studies, I will say, because case judgments are the primary sources, I will say that will be empirical study herein. Okay. And one of the problems of environmental law, which we discuss more in seminars and in the classes also, but not to that level, is the implementation of law. Implementation of law is not only of statutory law, not only of administrative law. Now, what to say and how to say? Non-implementation is even of the Supreme Court directions. Supreme Court directions. And therefore, when you will, I was saying that environmental law judgments end up in directions. You know, there's again a style of writing the directions. They not only say that municipality, you have to construct the drainage system. The Supreme Court will say you have to construct the drainage system within 6 months. Not only that, the Supreme Court also says, oh, this is the monitoring committee which we are constituting. This monitoring committee will oversee the work and submit us the report. This is the situation. And they are lamenting, Supreme Court are lamenting on this. They are regretting that whatever judgments have been passed by us, directions have been given, they have not been complied with. They have not been complied with. So this is a very big problem. And yes, research. You can do the research and then come out with a solution. Why is it that the apex court of the country, when it's giving directions in environmental law cases, why they are not complied with? First of all, come out with the extent of that. And unfortunately, you will find that it's a very serious note that non-compliance of even Supreme Court judgments, environmental law is not at all satisfactory. So the only the last point, you see, when you do the research on any one of the topic on environmental law, I will relate it the first point of my this address, that you will find the research is not only multidisciplinary but also interdisciplinary. Herein, one of the challenges for the researcher happens to be that the researcher get lost in that multidisciplinary, and law, and he or she loses the focus on law and goes more in the other areas. So you have to be very careful that though it is multidisciplinary research, though it is interdisciplinary, but your focus is on legal issues. What the legal issues are there. So don't deviate from them. Okay. So these are some of the thoughts which I have discussed with you. I'm really extremely sorry that I have exceeded my time. But if there are any questions, I would be happy to, quickly respond them. But that's on the organization. Thank you very much.
Thank you so much, ma'am, for this wonderful
Thank you
session.
so much, ma'am. Thank you.
Yes, sir. Please, sir. Adnan, sir, you have any query?
Uh, no, ma'am.
Okay, I
I
thought you.
was really astonished. Thank you so much, Tandon, ma'am. It was really pleasure listening to you. Thank you so much.
Thank you, ma'am. So moving ahead, I would call Dr. Neeti Sinha for the word of.
Thank you, ma'am. Thank you. Uh, for today's faculty development program, I'd like to say that this session really teaches us, and we can understand that way that whosoever teaches learns in the act of teaching, and whosoever learns definitely teaches in the act of learning. So, respected honorable guest of today's faculty development program on the topic teaching pedagogy and research skill, I would like to say thank to Professor Dr. Usha Tandon, Dean Faculty of Law, University of Delhi, and Professor Dr. Bharti, NLU Delhi, and Professor Gulam Yazdani, and our advisor, Sir Dr. K.S. Bharti, and my all faculty colleague, and dear participants. It's really a great day for all of us that today we are here in the second day of two-day faculty development program on such a important, and what we are doing as a teacher, we need time to time guidance from our learned people who are so much skilled in this profession. So thank you so much, ma'am. The way you gave interpretation related to the topic, the research skill and the teaching pedagogy, and at the same time, the complete and comprehensive introduction of the environmental law. So definitely, those who are participating in this faculty development program, they are going to be benefited, because as you mentioned in your address that at the time of teaching skill, the way we teach our students, case laws and case studies are definitely very important. And in the area of environmental law, one case will not be enough. Many cases, and the content of the judgment, and in what context the judgment has been given, that also plays very important role. So, and again, this area has great scope of research project, because we need to encourage our students in the to do research in the area of environmental law, because this is the area which is important for our existence and survival, because without this we cannot imagine our life for a very long period of time, not even for a very short period of time. So thank you so much, ma'am, the way you discussed the topic and the way you gave us the full introduction, and you taught us how to teach our students when we go in the class, because as we all know, today's students are already very much aware and updated. So only syllabus or only classroom teaching is not enough. And the way you also mentioned it, that the visuals and the group discussions and the cases are it should be a part of our classroom teaching. When we think about our teaching pedagogy, that is really very important. So thank you so much, ma'am, and we wish that again we get this opportunity to learn from you, to hear from you related to this topic and even other topic also. Thank you so much, ma'am. Now I would like to give
Yeah, I will
introduction
stay
of
here. I
our.
need to listen Bharti, even though I will switch on my video, but I'll stay for some time to listen you.
Okay, ma'am. Thank you.
Thank you,
Now,
ma'am.
I
Can I
would
just?
like to introduce our another resource person of this faculty development program, Dr. Bharti. She is a professor of law at NLU Delhi, and she joined in 2009, and she has a very long experience of teaching law since 1998, and she has been a student of Delhi University also, and has taught at the Faculty of Law, Law Center 1 and Law Center 2, Delhi University
I would like
before
to just
2009,
interrupt you here.
except,
So I am still a student of law,
yeah, yeah,
and I think I'll just start from here with your
that's
permission.
great. That's great. Yes,
Right.
yes, ma'am.
So
And
thank you
except
so
for a
much.
brief stint at
Yeah. Thank you. Thank you. Thank
Amity.
you very much, Dr. Neeti. I would like
Yeah,
to.
I just want to introduce our other participants of this faculty development program. They must know about the complete detail of yours, ma'am. That
So
is why I'm.
we can keep it very brief, and I think I'll just. So I'm teaching at National University Delhi, and
Okay, ma'am.
yeah.
Just one
So
or two line. She has
yes, sure.
been visiting faculty at Indian Law Institute, Institute of Constitutional and Parliamentary Studies, Bureau of Parliamentary Studies, and different trainings. And she has published various articles and made paper presentation on various platforms, national and international, on various topics of laws. And she has coordinated several workshops and seminars at DU. So now we all, as a participant of this faculty development program, are very eager to hear from you on the topic teaching pedagogy and research skill. Yes,
Right.
ma'am.
Thank you
Please.
so much for for the introduction, Dr. Neeti, and it's great to see you on the screen. And I would just like to share here that I share with Professor Tandon the my institutional antecedents of Delhi University, where I've been a student, and I also had the opportunity to teach. And I share with Professor Bhatti my antecedents of my schooling. It was at CJM, Convent of Jesus Mary, which is a kind of a next door school to St. Thomas, in that same area. So
Okay.
yeah, so I gratefully acknowledge, my all my learning and everything has really come, it's sourced in these two great institutions. So today, this is a topic which has been very adequately covered by Professor Usha Tandonji, and I think she has really extensively and very exhaustively looked at teaching pedagogy as well as the research pedagogy. So my topic is application-based teaching and research in law. So essentially, of course, there is uh, the application based teaching. It involves several nuances, and for a teacher of law and for a beginner, where the person is beginning into teaching, or is middle level, or is senior, I think the course of action is almost the same. It is the same level of seriousness which has to be taken for every subject, which is approached, for the purpose of conveying and communication in a class. So, of course, what comes to our mind is in application based teaching, there is a case study method, which is really the primary method and which is with which we are so well acquainted. It's really a given, especially in the traditional setups, and it has been adapted and adopted also in the 5 law schools. So it has its the whole case study method is the problem based learning. It is a kind of a guided inquiry. So it's what is important to note is that it should not consist of a kind of a monologue, or a kind of just recital of the case before the class. What is important is, because you can always bring in that innovative aspect even in a very traditional method of teaching. And here, the Socratic method, which is basically, the factual situation, which is kind of, taken up before the class. The issue is attempted to be pinpointed, and then what might be the arguments and the counter arguments that are, centered, and then you would come to a proper resolution of the case. So you would have a kind of a case study which is also having the benefit of a critical comment at the end of it. So a case study in itself can be read from anywhere. There are enough databases, and there is a lot of digital expansion of knowledge, of information that is there. But the role of the teacher is to string or to bring that thread between all these key elements, that you have a case, a hypothetical, or a real time case which is featured before the Supreme Court, the apex court, or the high courts. And based on those facts, then you would try to devolve on the crucial issues, and further on to the judgment which took place, and then to have a kind of a greater discussion as to whether that judgment was, in what context it took place, what were the kind of dissenting opinions in relation to that judgment, and in what way do you think that it really has its significance in today's context. So that is one thing. The other thing which I feel is true for every subject, literally every subject of law, except for maybe jurisprudence or the more theoretical based subjects as legal history is, that there is an application based content in every sub theme of law. So whether it is a law of contract, whether it's the law of family, the personal laws, there is environmental law which was mentioned. So there is a component which can be looked into, and you can work out the kind of the applications in that particular area. For instance, when you look at even environmental law, there is the whole possibility of looking into the public consultation dimension of environment impact assessment. So how this public consultation dimension, it can be improved in order to have a healthy and an environment which is clean, wholesome, and healthy, and which really is reflective of our pledge to have under the Article 21, as we know of. The other ways, of course, you have clinical courses nowadays in all law colleges, and this is again a mandate of the Bar Council of India. So you have approximately, I think, around 4 law courses, clinical law courses, as we have at our college, and I'm sure it's the same obtaining in every other college. So it is the trial advocacy course, the appellate advocacy course, legal aid, and there is pleading, conveyancing, and ADR method. So it really depends on how you're absorbing each of these as part of your mainstream subjects. And for the clinical courses, there is a greater possibility of having the application based content. That is, especially, because I'm also looking at legal aid and other clinical, the appellate advocacy courses at my college. And we usually entail the services or the expertise of legal practitioners, because it becomes relevant here. It is the you are trying to understand the kind of connect and bridging of the gap between the various legal postulates, the black letter law, as we say, and the practical dimensions of law. So, one very big constraint or very big kind of problem which is faced by students when they come out of law colleges and institutions is that they do not have enough of skill sets with which to really conduct themselves in the whole arena of litigation. It may be litigation in courts, it may be as part of law firms, it may be as part of legal consultancy at various entities, including governmental undertakings. So there is a need to prepare them well in advance. And I think the clinical courses, they become very relevant here. uh, there is the other aspect of innovative teaching styles, which uh, includes, simulation exercises, and you can have audiovisual presentations. You can have resort to open educational resources. Now, open educational resources, OERs as they're called, this is basically access to those resources which are in which there is no infringement of the particular material that you are taking help of. So usually there is a problem of the copyright belongs to particular individual. Although for educational purposes there is a very expansive meaning, which has been held by courts. Still, when we look at OERs, they become an infinite, they give you infinite possibilities for the purpose of incorporating those as part of your teaching. And for instance, the MOOCs courses, I think you would be aware of. These are the online medium courses that have been really come up under the aegis of the SWAYAM portal of the UGC. And there are a number of, we have, for instance, NLU Delhi has taken the initiative of floating around 9 such courses, and in the legal stream. And these courses can be resorted to in as part of your lectures, which is a very a safe way of proceeding. So sometimes you can have the benefit of that additional, this ancillary component, which has been formulated with a lot of effort and with a lot of materials that have been combined, for this purpose. The other thing is there are, of course, extracurricular activities at college, moot court activities. There are discussions. There are, the debates and client counseling, negotiation. There are uh, so many ways, so many dynamic and so many interesting ways in which you can really extend yourself. The teaching element can be extended to giving the students a very interactive environment, a learning environment in which they enjoy. So it is not just a one-sided kind of traction. It is a whole procedure that involves the students. Now, if you're looking at the kind of advantages of this whole application-based system, there is the possibility that you would be able to, when you involve students, their communication skills are likely to be, they would be affected in a positive manner when they speak in the class, when they are able to give a thoughtful direction to their conversations. There is the writing skills, which are going to be a very positive benefit. And in terms of writing projects, which was referred to earlier, and in fact, research projects is a very necessary component, of the 5-year law schools. For each of the subjects we have, for the purposes of assessment, there is a research area which is allocated to the student after due consultation. So it's not something which is a finality, and it is an authoritarian or a given. It is whatever topic is researched by the student is done so after a lot of interactions, and the final picture really emerges as per the choice of the student. and this process gives a lot of a lot of many advantages, because the student is constrained to look into various sources of information which he already has access to at the click of the button. But now these sources of information have to be more, they have to be well regulated. They have to be sourced through the official kind of sources, say for instance Westlaw or Hein Online or Manupatra or SCC. So there are so many ways in which you can have a better compilation and a comprehension of the particular subject matter on hand. There is also, I feel, there is a lot of increase in the sensitivity of the student to various issues which are plaguing the society, through various the kind of methods which may be used by the teachers, and to keep them interconnected with the issues or the real time problems of society. So, and especially through the clinical courses, you would find that the sympathetic, the empathetic, the kind of compassionate, these elements, they are say kind of there is a lot of value addition to the students. And in turn, a very important benefit of all this exercise is that more students are likely to join the litigation trajectory of their careers, because there is again problem of lesser students that are presently joining litigation because of the pull of the lucre, or the corporate law, how it has had its magnetic appeal. Also because there's a lot of investment of students in terms of, if they take admission to the 5-year colleges and especially NLUs. So it is not it is an investment on a large scale, and there is the need to have the due return. But it is also important and an imperative that the bar and bench, it is filled up with the right kind of the persons who fill up the bench in the bar. They should be having the right knowledge, and they should be able to affect the judicial system and the justice system ultimately, because the law and the gap between law and justice, that has to be bridged. And law is not just a, it's not just a statement, it's not just a provision, and that is where a lot of lacking remains. The implementation aspect of law, where not only the other segments of the governance, they play their respective roles, but the judiciary and all its branches and all its affiliates and all the personnel that are part of it, they have their very significant role to play. So you would find that as teachers, I think there is something important which needs to be kept in mind, that when we are looking at all these issues, there is a certain skill set that has to be existing with the teachers. And these the whole aspect of skill sets which really should be not only in terms of net, the nationality test, the basic qualifiers, which enable you to have a start to your formal initiation into the academic world. But there is a special skill set, which means that teaching in a class, facing a class of 60 or 80 students, and how to put across the law on that subject, how to put across the kind of changes, the amendments, the problems that are faced by society, to come up with adequate resolutions to them, and how to implement that law. So all these the sensitivity of the teachers, especially, and the technological updates. So the digital mediums have now you know embedded are they are now embedded very properly in our system now. Especially the pandemic gave us an opportunity to realize that how the distance can be overcome, the physical distance can be overcome through the digital forums. But of course, there remain so many other issues in terms of connectivity, in terms of the bandwidth. But apart from that, the teacher has to be technologically not savvy, even if not savvy, but technologically updated as to the various methods by which you can interact with the student. And not only, even though we are now looking at resumption of the physical realm, but still there is a lot of hybrid mode possibilities that are there. And you can continue the kind of conversation, the legal conversations beyond the class hours, in terms of tutorials, in terms of say research projects or any kind of supervision that you may conduct of students on different themes. So you can encourage students to write articles, and you would need to give them some kind of inputs as to writing of an article, or even the informal ways in which students now are exercising their the kind of knowledge that they have in terms of blogs, in terms of other means, newsletters, and so on. So there is so much of variety possible, that it has really come up in a very amazing manner. Now, when you're talking about the research skills in particular, so there is the twofold differentiation which is made between the doctrinal method and the non-doctrinal method. The doctrinal method is the theoretical, method which has traditionally been the way in which research has been conducted on the legal subject, and essentially it is called sometimes the library-based research method, the armchair method. And this kind of doctrinal method, it looks at basic postulates, the basic legal postulates or the basic legal norms, and it tries to verify the existing knowledge, on different legal issues, and to corroborate the correctness of those legal norms that are there. So you can, there's a lot of work, of course, which is done on doctrinal, as part of doctrinal research. The primary data in relation to doctrinal research, it relates to statutes, judgments, and the secondary data would come in terms of articles, and which provide an analysis of various case laws and all. So that is, of course, one way to look at it. The other method that has emerged recently, and which is really taking up from the sciences, the natural sciences, is the empirical method, which is a non-doctrinal research. So this is a more practical based research, and it relies on observation and not so much on theory. So it is the interactive aspects of law and society. So you identify a problem, and then you try to look at the legal principle that is involved, and you see the try to come to a result, and even to a kind of a solution to that issue through conducting that particular research. So I'll just give you a few examples so that it becomes a little more clear. But of course, when we talk about doctrinal research, which is a small segment of I'll pursue further. So even lawyers in their daily, the kind of engagements, they are required to look into. They are required to pursue legal research for the purpose of handling cases. So it is the doctrinal method that they ensure in, and it is basically to identify laws, including various statutes, regulations, the court judgments, and so on, that apply to the facts of a particular case, right? And so you would look at facts, you would look at the particular issue, and then you would look at the primary sources, secondary sources, and of course you would conduct the research in that manner. So when you're looking at non-doctrinal research, this is the experimental or the empirical method. Here, the a method of induction is used. So we generally contrast the methods of induction and reduction. Induction is where you go from the particular to the general. So when you're looking at empirical research, so you would pinpoint a particular issue or problem. For instance, right to education has come up through a constitutional amendment in 2002 and through a statutory enactment in 2009. So this particular, so you could formulate a, you know, a kind of a research question and an hypothesis revolving on whether the post this kind of amendment situation or the statutory enactment, has it led to increase in the number of enrollments, of students, and led to lesser illiteracy, or uh, the right to education has led to greater literacy of the segment of population between 6 and 14, right? So that is basically a research question. And so we are trying to go from the particular to the general. So there is a particular aspect, and this is all relative. So you could have even a smaller kind of a pinpointing of the issue, and then you can extrapolate it. So here we are looking at whether right to education, or if you take up the statutory enactment, whether it has led to increase in literacy for the segment of 6 to 14. And the hypothesis is that perhaps the kind of literacy or illiteracy that was prevalent in India, this will be the illiteracy in this segment is going to be lower in the post statutory enactment phase, and you have to prove or disapprove this hypothesis. So you would then accordingly work out the empirical study, and this kind of empirical study becomes very relevant, or highly workable for certain areas of law, especially in the area of criminal justice system, in the area of family law. You find that the empirical system has a greater tangible, the way you can conduct it. It's easier because the subjects are they lend themselves easily to the kind of the empirical, the whole study of quantifiable or quantitative or the qualitative analysis, and the further the kind of verification and the conclusion of the particular study in itself. You would find that the empirical research becomes very hands-on. So its role has been, it has been highlighted through a very important case. This was in US. This was a case, Muller versus Oregon. This is Mulleer versus Oregon. This is a 1908 case. It is a US Supreme Court case in which, for the first time, a lawyer used empirical studies for the purpose of his argument. And it is an early case, 1908. So it just goes to show, although the empirical or the application based teaching as well as research has become much more you know uh, much more favorable, or it has found a lot of application through the 60s and 70s, that is really considered to be the starting point. But you find that it was much earlier in 1908. And what happened was that there was Louis Brandeis, Louis Brandeis. He was Attorney General of Oregon, and later became a judge also the Supreme Court in US. He supported the argument that factory laws should be, the factory hours should be shorter for the women as compared to men. And he demonstrated it through an empirical study that was conducted. And this was basically on the grounds of physiological, of health reasons for women. So it was not a case of personal se gender discrimination, but it was more for the purpose of protecting women and because of their whole physical attributes. And this kind of a study, so you find that empirical studies, they have their role and their huge value for the for taking decisions, for judicial decisions, for the lawmaker, for the legislator, for the administrator, and it is part of legal education also that it has emerged as a very significant area. So when you're looking at the major sources, the way the any kind of research study is undertaken, literature review is one of the most research study. We do not give it that kind of adequate highlight, but to my mind, it really sets the tone and the possibility of a successful research doctoral thesis, right? Whatever the research project or the doctoral thesis that is being conducted. And so because as teachers, we can take up projects which are which are extended by ICSSR, or there are so many the NHRC, and there's so many forums on which projects are circulated. And you can, there are minor and major projects. It used to be that kind of a distinction earlier, but certainly, as part of your PhD program, or as part of these various research projects, be literature review. So when you're talking literature review, it really means to extensively look in the title area, the topic area that you wish to launch yourself into for the purposes of your study. And it would really show you the gaps, because it would take you through the entire journey of whatever work has been done uh, you know, uh, in that particular theme, and it would help you to aspire or to see those gaps or those possibilities where you can make your contribution and a value addition, because research is essentially to do with an addition to existing knowledge. That is how we usually define it. So it is perhaps in that sense. Moreover, I would say that apart from literature review, there are the normal steps to a research design, which is of course research questions, hypothesis, and research methodology, the chapterization, and in case you're following the empirical method, then of course you have the kind of technique which is being used. Is it the questionnaire, is it the interview method, or and the kind of the final conclusions of that, the whole data, the sampling that is being conducted. So, and of course to end with bibliography, because bibliography, which indicates the sources of all the wherever you have relied upon for the purpose of of that subject. Moreover, footnotes are a very important component. Footnotes have to be, they have to follow certain rules, and there is a blue handbook, and there are so many other ways. Every institution nowadays has its own method of putting across the footnotes. I would also say that in this whole process of research, it's very important to identify collaborators, or because it's difficult to research single-handedly. So it can be institutional, it collaboration with there should be a possibility for the interaction. It would be always helpful to have certain experts which are associated with your research, so that in times of any kind of difficulty or any kind of ambiguity, it can be immediately resolved, with taking help of the people. And of course, timelines have to be finally, that's a factor which needs to be adhered to, and it should be so that undue delay for the project that needs to be submitted. So I guess there are these some pointers which I think are relevant to for the purpose of meaningful teaching and meaningful research. This is in today's world that we are. It's highly interlinked, and whatever development is taking place in any part of the world, we are privy to it and we can have access to it. And there are so many themes and sub themes which can be part of our teaching and research. And every institution, I think, gives that kind of moderated. I mean, the freedom is there, the academic freedom is there with every teacher as to how to put across that subject matter which is there with you. So you should talent for the and keep yourself updated with the latest technologies, with the latest methodologies, and I guess you would do very well. So I'll just end the discussion. I mean, it's not a discussion, it's really just me speaking. And in case if there's any question, that is welcome.
Thank you so much, ma'am.
Thank you so much.
The session, the session was really very nice, and I'm sure it will help all the research scholars and teachers like us in future. So, if anyone has a question, you may ask. Otherwise, ma'am, we have a session after the completion of session for question answers.
Right.
So, should we move on with the, yeah,
Yeah, yeah, sure.
okay.
Thank you
So,
very much, Professor Bharti.
Thank you, sir.
Thank you so much.
thank you, ma'am. So, moving ahead, I would like to call Mr. Adnan Irshad to introduce our guest and resource person, Dr. Ghulam Yazdani, Associate Professor of Jamia Millia Islamia University, Delhi.
Good afternoon, everyone.
Yes, yes, you are.
Our yes, please. Now I would like to introduce our honorable esteemed guest, Ghulam Yazdani is member faculty of law as a young intern law. He has been a vivid scholar in the field of personal laws, especially women's rights, vis-a-vis the jurisprudence of Islamic law. Sir is a regular visitor as an expert to different institutions. Sir will be discussing regarding pedagogy of because since last 2 decades to America as well as personal law change. So I would like to and above all he has a guide now to kind
cultural, educational aspect. The origins of the modern legal system in India can be traced back to colonial time, and the Bar Council of India regulates the legal education curriculum in both private as well as the public education institutions. Now, that what kind of the teaching methodologies be taken into account, which can contribute in the field of teaching, learning methodologies, and the gainers can get advantages of institutions, whether it's the public or the private. Teaching methodology comprises the principles and the methods used by the teachers classes to ensure maximum learning output from the students. The strategy is determined partly on the subject matter
I
and
request you all to please
taught.
switch your mute your mic.
Yes, some
Yeah,
voice
it is
is echoing.
requested to all the participants kindly mute
Please.
yourself and only Dr. Ghulam Yazani sir shall speak because it is disturbing. Sir, please continue. Sorry to interrupt, sir.
Okay. The teaching methodology, which has to be adopted in the legal education in the institutions, those are imparting that legal education. The methodology, which is in fact must comprise the principles and methods which are used by the teachers to ensure maximum learning output from the students. In this regard, the very strategy is in fact determined partly on the subject matter to be taught and partly by the nature of the learner as well. In this context, that I would like to mention some of the methodologies which are in practice, like teaching, methods, and what kind of the difference that we can draw that what teaching methodology is and what are the teaching methods. The teaching methods are the principles and in fact the methods which are employed by the teacher to impart the knowledge. The teaching methodology involves the strategy and understanding to choose effective teaching methods, curriculum, and the pedagogy, considering the very requirements of the subject and the learning ability or the nature of the students. Now, coming to the very practices which are in the being practiced, those are in place in the legal institutions, in the law colleges, law universities. They are practicing those methods, like very well-known methods. I am just in the briefly mentioning those things, like case methods, problem-based methods, discussion methods, are simulation and the role play. which also plays a very important collaborative teaching as in practice in some of the institutions are focusing on collaborative teaching, but all institutions are now adopting all which can enhance and contribute in the learning processes in the that law schools and universities. Seminar methods and the clinical methods, the particularly that I will say the clinical methods in the legal education which was initiated and emphasized in India by our late Professor Madhav Menon Saab, who in fact given very shape and by whose initiative that law schools started much more focusing on the clinical methodologies in the law teachings. The purposes of all these teaching methods are to create professional values and skills in the students. However, the other than the teaching, the supervision and evaluation of the students' performance are equally important aspects in the legal academia. Now, the teaching methods which generally are referred in the law teachings, like Socrates, the dialogue methods in Socratic methods of teacher using the dialogue with the students to enlarge and also engage and impart the knowledge instead of imposing knowledge on the students. The Socratic the methods which relies on the gathering uh, and also the among the students, developing and generating the inquiry among the students, and by that pondering that the knowledge with them about the answer to the very discussion through these methods. The Socratic methods believe that there can be a number of the solutions to the same problem. Also, a single result can be reached by the various parts of the inquiry by the Socratic methods. Now coming to the adversarial methods. In this method, a real life problem is given to the students. In case of law education, it means filing a case or a representing in original suit that inter meaning the with the senior in the class and the in the fora, having the group discussion or clinical methods or other practices in the legal education. In this context, that in the clinical methods, the a mock problem representation based on real life legal issues is provided to the students. This is helping the students to get a practical idea of the functioning of the law. For example, participating in legal aid programs or legal aid cell wherever that law schools are having and operating such legal cell, legal aid clinics, that helps a lot. And also the moot court activities and the parliamentary debate, etc. These are constituting the clinical methods in the field of the legal education and the law teachings. Now coming this the new that the e-learning and the MOOCs, etc., are the new developments which also contributes in the field of law, which are being practiced. During this COVID, that we can say the phygital and the blended methods are being practiced. After COVID-19, the pandemic has been a tough time. All we know out of having these experiences that all we have faced and also overcome with the very challenge that we have seen last more than 2 years. This has been, in fact, seen the methods of teaching during this time, which we can say help for evolving new methods of teaching, like the blended teaching or physical teaching or online teaching classes and teaching learning methods have become a usual phenomena nowadays. As of now, we are sharing and in the online this the teaching to help and also to achieve teaching objectives despite of this COVID-19 challenge that we have largely learned out of this challenge. And after confrontation with the many technical and other challenges, that the practice of teaching and teaching methods have also adopted accordingly, which we can say in this time the very information communication technology and is a blend of this into that everyday teaching and overhauling the contents and delivery and also evaluation system to this period of COVID-19 has overcome the many challenges of uncertain time, like the pandemic, which has been a great difficulty, and we have really overcome with the same challenges. The strengthening the very resilience among the students towards the new challenge that has also been due to this COVID-19. Improving the digital pedagogical methods are usually become a routine practice by the users in all school level, from the very junior school to the higher education level, and the teachers also having learned a lot and did good experience in the digital pedagogical methods, etc. In this context, that we can say, coming to the very aspect that the teaching methodologies in the personal laws areas, what are those principles of teaching adopted are taken into consideration to give emphasis to the personal law discipline. The personal law, which relates to marriage, divorce, succession, inheritance, maintenance, custody of children, and adoption, etc. Before this, I would like to share what is the sociology and the jurisprudential aspect of the personal law. Let me tell you that about the need for understanding the sociological and the jurisprudential aspect, that the personal law works within a community. Therefore, that empathic socio-jurisprudential study of the very religious practices and the community is the prerequisite in this regard. We have to look into entirety in this. For example, a Muslim law cannot be seen diverse from the sociology of Muslim community and objective under understanding of the Islamic law in South Asia. Similarly, the customary law of Hindus that cannot be comprehended without studying the jurisprudential context that under which the law operates within a Hindu society. Therefore, there is a pressing need for including the sources and the schools of these laws, which are not part of most of the syllabi wherever the subjects of Hindu law or the Muslim law are being taught in all such schools uniformly. The very percentage of the course and the topics, they vary from school to school. There is no uniformity or any holistic consideration for having proper and effective deliberation amongst the students, those are studying the personal law subjects. There is a pressing need for including the sources and the schools of these laws, which are not in fact part of the most syllabi, and those students in fact do not get the basic framework of which these laws operate. In fact, going in some of that aspect, that the personal law, how that in Indian law schools are being valued, are also that they're in its incorporation or coverage, or having the deliberations covering the personal law aspects. Looking into the syllabi of the personal laws which are being taught in that Indian law schools will in fact reveal that the legal curriculum is most unsatisfactory if we apprise them and analyze all the law schools wherever it is being taught in the name of that the Hindu law or the Muslim law as a subjects. Many of the things which are included in the syllabi and are prescribed material for the subject being referred in the personal laws are to some way it is unauthentic or unscientific, and often devoid of practical utility in the those course contents wherever it is being covered or taught. In the some of the law faculties may be better, but most of the law faculties are not having the holistic and the balanced approach to cover the personal law subjects to be included for the learning of that students in the law schools. Therefore, the first and the foremost step is needed to be bring about that the problems and the difficulties, and also evolve a useful and satisfactory program of study to cover the as a holistic approach for the study of the personal law is required. Towards the very objective, which in fact I can say that uniform the aspects in the personal laws are being seen in most of the law colleges, which needed to be pondered on. First, that the standardization of the subject, like the name, particularly with the respect to the personal law as being taught in the Indian law colleges, universities. For example, using the anglicized word like Mohammedan law, it has been agreed is a misnomer and is colonial term, which is both the unscientific and unfounded. Also, Hindu law cannot be called Vedic law, and by the analogy that the very term Islamic law cannot be adopted in Indian law schools in toto. Use of the very term that Muslim law has been advocated by pioneering the Indian Law Institute in the 1970s. This the term appropriately started the very initiative taken by the Indian Law Institute. I think Dr. Bharti Saab will be aware of, because he has been a long time in the Indian Law Institute, worked as a registrar of ILI. Then many eminent jurists, academicians, and the institutes late, we can say, have said the same for using appropriate terminology for calling like the Muslim law rather than Islamic law or the Fatimid law or something Muhammadan law. Also, some writers use that. That is not appropriate. The appropriate term is better to call Muslim law. Curriculum, so far that it's designing for the teaching and the relevant aspect of the personal law, that which can help for making a holistic view in the area of the personal law. In some universities, many important aspects of the personal law are ignored or not covered in their curriculum. It has been found that many of time that there has been inequitable distribution of the legal aspect of some of the minority communities, and the very importance to determined by the unmentioned rules of the number are over the objectivity. For example, that like Parsi personal law or the law applicable among Sikhs or the Christians, Christian personal law or the law meant for the Jewish. In fact, which acquired the very that least as space only in the limited to the very topics of marriage and divorce, not entirety that the law which is applicable for the tiny communities in the name of the personal laws. Other important aspects of the law are in fact conveniently ignored in the teachings of the personal laws. That even the coverage of Muslim law is also proportionately very limited. Sometimes the numbers are to be taken as a parameters that Muslim law syllabi which predominates like Hanafi law as Sunni law. However, the Shafi'i school of law, who more than the Shias, are almost completely neglected in the course coverages made by various the law schools, including the national law schools and their syllabi. And if anyone can analyze the very balance comparative that study of personal law can be a better way for looking at various issues. The Muslim personal law, which have been codified and reformed in a large number of the countries. Similarly, Hindus in Fiji Island, Southeast Asia, Caribbean island, and Africa have evolved and reformed many aspects of Hindu legal philosophy, Hindu legal jurisprudence. However, that students of law in this country, especially at the very undergraduate level, get no chance to have a comparative study of the of say that cross country Muslim law or the cross country Hindu law aspects. By tradition, that personal law is treated as a religious law or the community-based legal system, though it would have been far better if India could successfully evolve, a stream of personal laws as uniform civil law, which is a long pending issue, or that the matter, though very recently the matter has been brought before the Supreme Court of India by filing the public interest litigation. But this issue is somewhat will need a very big exercise involving all the communities as stakeholders, because we can simply make theoretical ideas can be done, but practicality has to be seen with that idea of uniformity in the civil law. The very idea behind having uniform civil code, which has recently been referred in, I would like to say, because this aspect comes under the domain of the personal law, which can be truly appreciated when that good from all personal laws has to be accepted and the bad has to be discarded. Understand? For understanding and any debate on the contesting issues of private law, there need to be deliberation considering all the stakeholders involving the including the government, that religious law experts of the community in question, and the very subject matter experts, that social scientists on the very subject which is need of the time, before having a holistic approach for evolving a common civil law. This will in fact make the teaching and research of that the civil law in the private or the personal affair more holistic approach for this purpose. Now, looking into the some other aspect, that the curriculum design which needed to be regularly updation is required. In some selected the cases can be said to have been done. In most of the Indian law schools and the universities, the selection of the case law, or we can say the example, we can say that landmark case law is not fully satisfactorily wherever that this exercise has been done. But it is not very common that so far developing or providing the case law facilities among the legal learners. The old cases which have rather outlived their utility are being taught, while many recent cases of great importance are not being covered in the curriculum. They are left out, which need to be regularly revised at every law schools, that the very responsibility of that those institutions and the heads and deans and directors must take into account with the latest developments, has to be incorporated in their curriculums. And also the teachers in their respective faculties, respective colleges, they should also brought in the discussion with the students in the very recent legal updates. The very syllabus is so rarely in fact updated that I can say that one of the professor who has prepared his class notes of his time in the subject concerned on including I'm telling you the personal law during his student life or 80s, and has been teaching and carrying with those notes with him while having the class with the students. referring those classical and obsolete the knowledge sources throughout his that the his life that he was in the institution. This kind of practice is in fact going to be rejected, and all redundant the knowledge sharing with the very updated students. If a teacher teaching in law are referring the outdated cases, certainly is nothing but making or mocking on itself, which certainly be taken a very serious aspect about the law schools for making homework, updating their course contents and syllabi, so that the very latest information be brought in, and in the deliberation and in discussion with the students. The very curriculum in some law schools and the universities, which generally includes the topics which I would like to tell you. For example, that there are useless and also obsolete. For example, that no purpose is served teaching of that muta marriage in the Muslim law, wherever it is included, wherever the law school or the of the state university or the central universities, which is an obsolete topic as a teaching, the concept of niyoga among Hindu law also. In the Muslim law, as a muta marriage is found in the courses, and the concept of niyoga in Hindu law also somewhere I have seen is being included or taught in the law schools, which I hope that you'll be aware of that the Niyoga, which was an ancient Hindu practice, similar to the living, leverage marriage, which literally meaning is without union, and that the ni means without, and yoga means the union. Okay, this concept is also existing in some course contents of some of the law colleges, some universities. In this kind of the practice where the obsolete the topics are constituting the course contents. Similarly, for example, I will say that the concept of zihar, when the husband in fact compares his wife with mother or sister, and another kind of divorce under Muslim law called ila, means constructing the divorce on that oath, which are the practically of no use in the contemporary times. Okay, under the Muslim law, these topics need not to be discussed in the class. They have lost their significance, and coming to the very the sum of that aspect, that in the personal law streams, having the curriculum and books and references, etc. All that sort of the books containing the if we see there's some books are having the faulty material, and the misinformation and the wrong exposition of the Hindu law and Muslim law are also used in some of that the law schools. For example, that I will say, while that authentic works like the very context of that Muslim law, those of the Amir Ali.
I am so sorry, Professor Yardani. May I request you to kindly conclude your very, very enlightening address?
Yes, sir. I'm summarizing.
Thank you, sir.
Okay.
Thank you, sir.
While having the authentic work like the on Muslim law by Amir Ali and Tayyib ji are the very too high standard for the undergraduate level syllabus, and at the same time, when we see the Hindi medium that instruments which has been adopted many parts of northern India. There is a very few authentic books on the personal law in that language, where that Professor Sinha of Allahabad and the R.K. Agarwala Paras Diwan on Hindu law, and Professor Tahir Mahmood, Furqan Ahmed, and the Iqbal Ali Khan written, translated, and revised many books on Muslim law, which are popular and the useful reading material in that regard. The case law and the rulings in the case of the personal laws are not without problem, and it is also difficult to make an understanding sometimes with the very conflicting rulings in the personal law. In such situation, that the law teachers must refer the latest updates that which are coming from the Supreme Court on the very topics, and go through entirely, and make the balance understanding to those. Sometimes even the framing of issues, which I will refer the very recently, is not appropriately done by the courts, leading to erroneous judgments. And the nature always, in fact, if it is said that always gives right answer if the very question put to you is right. For we can say the very recently in hijab ruling of Karnataka High Court, the framing of question on that are not was the question, and accordingly the court has to go ahead with, and hopefully that the Supreme Court will make some better opinion in this regard. There is a good deal of, in fact, if we see the misunderstanding about the subject of personal law itself, which is in fact aggravated by the coverage of that the media, and also in fact sometimes blown out of proportion in many that in the public at large, which opinion both pros and cons that usually exist. And the most of the people, in fact, believe that we do not have a common civil law in this country. The very reality is that all civil laws are common except the one that is the personal law, which varies with the religious groups, the community-based legal system, which is constitutionally, recognized. Though we have so many the laws which are uniformly applied, like a special marriage a law, Indian Succession Act, and the Guardianship and Wards Act, etc. Now, I would like to, in fact, sum up that I would like to say that the very appropriate teaching methodology should be adopted in the law schools, to bring uniformity, and to also evolve that system which can generate the harmony, peace, and also that the in the interest of nation and the society at large. In this regard, that I would like to say that if any it is having any question, that we will welcome. And thank you, Dr. K. Patil sir, and the college in organizing the program, having teaching pedagogy and legal. Yes, sir.
Thank you very much, Professor sir. Thank you so much. Sibi, what is the now? Am I supposed to conclude it or what?
Sir, I think
Yes.
we shall have a Q&A session, sir. If the esteemed guests allow, we can have a Q&A session, sir. if Professor
Yes,
Dr. Bharti and Professor Dr. Ghulam Yazdani allows.
yes, yes, yes.
Professor Bharti?
If anyone
Yes.
having a question, they can ask.
So, shall I conclude?
Sir, if you allow me, then I can ask something, sir, please.
Time is overshot, Adnan. Now let's close it. So we'll meet again and again.
Sir, because we have very enlightened guests, that was the reason.
Yeah,
Because
they
we
are
will
treasure
clearly
of
experience
knowledge. We
together.
have to share. We have to learn. So,
Exactly.
Simi, shall we proceed to conclude?
Yes, sir.
Yes.
So, first of all, I record my grateful thanks to the great scholars of law of the country, Professor Manoj Kumar Sinha, the director of the Indian Law Institute, Professor Usha Tandon, Dean of Law Faculty of University of Delhi, Professor Bharti Kumar, the Doyen of the National Law University, Delhi, and Professor Ghulam Yazdani, the Dean, the Doyen of the Jamia Millia Islamia. Really, it is a great privilege with us
Thank
that
you,
the
sir.
four great institutions of the country, four great institutions of the country are here assembled at the St. Thomas, and we are really privileged. I think Professor Bharti would agree with me, and Professor Yazdani would also agree with me that
Thank you,
this
sir. Thank you so much. At least we
is
are listening a very uh, legal luminary, Dr. Bharti. I know that from my student life to you, and
Sir,
today I
I
am.
remember actually Professor Tahir Mahmood used to say that Indian
Ji,
Law Institute is a factory which
yeah,
manufactures the legal luminaries like
yes,
you, like
yes,
Professor Bharti, like Professor Usha Tandon, like Professor Manoj Kumar Sinha, and this is our first maiden FDP. We'll
yeah,
continue to hold this program. Lot many great advice and inputs have been given by Professor Tandon, Professor Bharti, Professor Yazdani, Professor Manoj Kumar Sinha. It will go a long way with the teachers of the law, those who have all assembled here. I suppose some of them have left also. The
yes,
great loss to them. They won't have
Exactly.
yes,
opportunity
yes,
to hear the legal memories like you here. So I think this is a loss. But of course, our faculty members, they are enriched and they are enlightened. And Professor Bharti, I have no words to commend that your clinical method of the trial stage, of the appellate stage, and the legal stage. This is wonderful of you. I compliment you and the National Law University.
Thank you, sir. In fact, it's absolutely a privilege to be here. You have made a very significant comment that institutions which are prime in the legal education, they are एक उनका यहाँ पर इस forum में उनकी एक presence थी institution and Jamia Millia and Delhi University and National University Delhi. So I must commend you for this very great initiative, and I hope you carry forward your leadership and under your inspiration, this institution is going to prosper because you are a
Your blessings are
very
needed, and your blessings would go a long way. And our faculty members, this is all their creation. This is all their they only they motivate me to just I approach you people, those who have been my mentors. No, that you are all here. I really express my great gratitude to Professor Manoj Kumar Sinha ji, Professor Usha Tandon ji, Professor Bharti Kumar ji, Professor Yazdani ji, and I compliment Mr. Mohammad Fahim Khan. He has
Thank
been
you.
the
yes,
architect of this whole program.
yes,
So
yes,
it has been a great sangam of all rivers of the country, I say. So we will meet again. We will take your valuable time again and again, and we would like that our teachers, community, our law students, as you said very rightly, there is a lot gap between the education, legal education, and the legal practice. So this gap has to be filled up. So
yes,
I have no words on behalf of our most reverend chairperson, Dr. P.C. Singh, on behalf of vice chairperson, Professor S.C. Panda, on behalf of our director, Dr. Anurada Amos, and my behalf, and on behalf of all the learned faculty members of our college, and all teachers, those who participated in this program from all the states of the country. I convey our gratitude very hard. Thanks all of you that you spared your very valuable time and shared your wisdom, shared your pearls of knowledge, participants over here. So I would now only request Professor Dhananjay Mishra to propose a formal vote of thanks. My gratitude to each one of you for sharing your wisdom and knowledge with us. Thank you very
so
much.
much, sir. Thank you. Thank you.
Thank you, sir.
Vote, who is proposing vote, Fahim or Dhananjay?
Yes, yes.
Anybody?
Good afternoon to all. Respected Dr. Bhati sir, respected Dr. Professor Bharti ma'am, respected Dr. Usha Tandon, respected Dr. Ghulam Yazdani sir. On the behalf of STCL, I take this opportunity to propose a vote of thanks. First and foremost, I would like to express my appreciation to the respected Professor Manoj Sinha sir, Professor Usha Tandon ma'am, Professor Bharti ma'am, and Professor Dr. Ghulam Yazani sir for their valuable contribution to our FDP. I would like to extend my heartfelt gratitude to our esteemed guest, Professor Usha Tandon ma'am. We are really enlightened with her knowledge and presence. We are also thankful to our Honorable Dr. K.S. Bharti sir, Advisor STCL, Dr. M.K. Tyagi sir, Dean STCL, for their motivation and enthusiastic support. A special thanks to the faculty member of their unflinching support and coordination. A special thanks to faculty member for their unflinching support and coordination. Finally, I would like to thank all of you present here for making the time to be with us today and helping us this event's grand success. I hope you all have gained a better understanding about the evolving pattern of teaching, learning, and research skill. Thank you all. Once again, I would like to thank all the esteemed guests for their valuable contribution.
Thank you very much.
Thank you. Thank you so much.
Thank you, sir.
Planning to organize the seminar, we will definitely further ask you to participate. And okay, thank you.
Thank you.
Best
Now
wishes
you
to all the
Thank you,
faculty
ma'am. Thank you, sir.
Thank you, sir.
Declare program closed.
Thank you.
Thank you, Yazdani sir.
Thank you.
Thank you very much, sir. Thank you,
Thank
Professor Bharti.
Thank
Thank you, Yazdani sir. Thank you.
Thank you, sir.
Thank you,
Thank
all
you so much.
faculty members. Thanks a lot.